Pop it up. So just to give you my background, my normal job is to be a corporate and projects lawyer, more like an executive general counsel level now. I started work with those two firms at the top, Herbert Smith, Freehills Kramer and DLA Piper. DLA Piper is one of the biggest firms in the world. HSFK is one of the biggest sort of Anglo-Atlantic, Anglo-American firms now. Minter Ellison and Hogan Lovells more recently in my career. Between the two, I was a partner at Minter Ellison and Hogan Lovells. Between the two and then after, I've worked at these companies sort of as general counsel or senior in-house counsel. And in particular, the one that I'm at now is Mitsui & Co., which is a big Japanese trading house. So through that world, I've spent my life working in big corporate transactions, and I've seen a lot of contracts and reviewed a lot of contracts, including NDAs, which is what we're going to focus on a little bit today quickly, and then a couple of other agreements at the back end. In fact, I did an NDA yesterday on a deal, so it's pretty fresh. Okay, next one, please. All right, so I've given it away here. An NDA, does everyone know what an NDA is? Do you know what non-disclosure agreement? Do you understand the purpose of it really, or importance of it? What would you say?
Stop people from sharing unlawful. Like if I'm giving you my trade secret, I get you to sign the NDA, because then if you go blab it, I'll take you to court. Correct.
Yeah, and you just hit a really important point there, which we'll come back to in a little while. That's exactly right. It's a non-disclosure or a confidentiality agreement. They tend to be punchy, 6 to 7 pages. They can be 1 page. More complicated ones can be longer than that. They'll tend to be probably, I might be wrong here, the first thing that any of you guys are likely to have to deal as a contract document in a startup world. It's the first thing you're either going to receive maybe, or it's the first thing you're possibly going to give to someone, other than a shareholder agreement or a governance document, which Charlie's spoken to and we'll come back to a little bit in a second. You might also want to consider it, you can use them in a variety of different ways. You can use them obviously with potential investors, with customers, but also, and relevantly for all the founders here, you want to think about them with employees and you want to think about them with your interns, because in fact, what we're all doing here is sharing data with each other. So none of us, well, it's needless to say, I think probably the concept is that everything's meant to be kept confidential here amongst us, but no one signed any agreement saying that. So if you're sensitive around this thing, you should have an NDA in place. And exactly as you said, the aim is to manage the confidential and really valuable nature of your information, and you'll define that by the terms of your NDA. It can be an awkward sort of a thing at an early stage, especially when you're just getting going, to sort of be presenting an NDA, and working out when's the right time to present one is one of the key issues, I think. We can come back to that in a sec. Thanks, Tom. So let's just run through the normal things that are contained in an NDA. That's just an example of one up there that I use. There's a couple of things you'll always go through in the process if you start speaking to, say, an investor or an employee, probably more an investor, or a potential customer or someone you're seriously wanting to talk to your business about. So the first thing is, do I want to give them an NDA? Now, if the person doesn't know you and it's a bit of a cold call and you try and slap an NDA in front of them, they're likely to go, you know, forget it. You're wasting my time. You've got to have a pitch and you've got to have enough information that you can share with someone without needing to put an NDA in place. But if you're going to start getting into a lot of detail, if you're going to start sharing code, if you're going to start sharing architecture or details, you're going to start sharing stuff that you feel is very, very important for your business, you might want to think about an NDA. So the first thing that's going to happen is, if they're sophisticated and they're used to it, they'll be fine with saying, we'll take one, no problem. It will be, do you give them yours or do you accept theirs? And they'll be, you know, obviously it's better if you have your own one, you give them yours because you'll be more comfortable with it. If you're dealing with any big players, venture capitalists, anyone like that, they're likely to give you theirs. So you're going to have to review their one. So what are the things you want to look out for? Just some key points, because we're just seeing the highlights today. An NDA can be either one way or two way. If it's one way, it's just you disclosing information to them. So they're the recipient, and the NDA only covers data that you're giving to them. If you talk about going the other way, they won't release anything to you because they're not subject to any or they're not getting the benefit of any obligations of confidentiality. So a two-way or a reciprocal NDA or confidentiality agreement is one that makes any exchange of information between the two of you both subject to confidentiality obligations. So, you know, if you're talking to a potential partner, for example, you might want to look at having a reciprocal or a two-way NDA where it puts you both under obligations of secrecy for the exchange of information that goes on. Look, the standard sort of provisions as you look through these things, they tend to be pretty much the same sort of thing each time normally. Once you've read a few of them, you'll find the same stuff. Obviously, the core obligations is you have to keep things secret. There's obligations on you to do that. The big question is, how far does it go? What's the scope of that confidentiality? What's included in the information? Or if you're being put under an obligation, check how far that is and whether it's unreasonable. Particularly check the duration. How long do those obligations last for? If it's a very long time, if they're saying 5 years, you sort of go, whoa, no, that's too long. Obviously, if you're the one trying to lock someone else up, the longer the better. Generally, people talk about 1, 2, 3 years as a reasonable period for confidentiality obligations. In particular, look for what's excluded from confidentiality. And again, it depends on whether you're the one disclosing or the one receiving. But for you guys, it's going to be mainly as a disclosure. If you're disclosing information, you want to keep them as locked up as they can be, and you want to have as few exceptions as possible. General exceptions, of course, are if it becomes public information, it's not subject to the obligations of the NDA. If someone's required to disclose it because they get sued or by court order, that's an exception. And there's a variety of other exceptions you'll see in there. And then generally they have other formalities in there. They have notice provisions, they have non-assignment provisions and so on. Sort of boilerplate stuff generally. Let me just pause for a sec. Does anyone want to ask any questions at this point? Yeah, so NDAs are probably one of the simplest contracts and probably the ones that's best suited to AI. So don't get me wrong, I'm not suggesting you don't use lawyers, and AI is not giving you legal advice. So if there's a problem with it, you won't be able to go and sue the AI. But I would also say that any NDA is better than no NDA. So if you don't have the money to engage a lawyer, you don't know one, get one off AI, have a look at it, use common sense and go with it. Yeah. And exactly. Yeah, exactly right. Yep.
Why not 10 years?
You can try and lock someone up. So it's a negotiation. So it's two sides. Generally, the other side will never agree to be locked up for 10 years. It'll be hard enough if you're dealing with an investor or a venture capitalist to lock them up under an NDA at all. And then it'll be a pushback on anything you're trying to apply to them. Because when you sign up to an NDA as an investor or as a counterparty, you're locking yourself down on what you can do. And if you go and speak to other people that have got similar ideas, you suddenly become very conflicted about what you can share with them. So everyone who's on the other side of an NDA will try and reduce it as much as possible. So for you as a new business founder, you want to look like you're professional and you're trying to do the right thing. But if you make stupid asks, you're going to lose credibility. A 10-year ask is going to do that. They're going to go, you're kidding. You're wasting my time. That's where going and seeing a lawyer or even asking ChatGPT to give me industry standard is not a bad option, because you don't want to lose credibility in your negotiations here. Was there any other? No other ones? Okay, maybe next. Sorry, Charlie.
Highly reticent. In fact, they probably will they'll kick you out of their office rather than sign an NDA. So what do you do then? You just go, well, I'm in control of what I tell them. If they're interested down the line, I might tell them more.
Yeah.
It's like, how do you, that judgment of, if they're refusing to sign an NDA, I'm not going to read a 6 or 7 page thing in front of you. Do you just carry on?
Yeah, it's a really good question, Charlie. It's a really difficult one to answer. I think you've got to make a call on the value of the meeting you're having. And I think at the early stage, you probably need to not push too hard on this. If you've got to a point where you're advanced enough or they're asking you to share something where you just don't feel comfortable sharing it unless there's an NDA, then hold your ground. If you're just doing early stage pitches and they go, no, we're not signing an NDA, you'll just have to be careful about what you say. And what you can do is say to them in the meeting and make a note of it for afterwards this is confidential. I just, I want to talk to you about this, but obviously this is confidential. You say that, you've got a record of it at least, and then you can rely on that. That's probably the best you can do. But what Charlie says is right. There's only so far you can push with these things. Yeah.
Investment got your head screwed on, you're giving everything willy-nilly.
Yeah.
You're not going to bend over it because you want someone to be tough, right? If I'm investing in you, I want you to be tough.
Yeah.
You're going to have to go and negotiate with some tough people. So
exactly.
If you're not negotiating with me, that's a good sign.
Yeah. Yeah, I agree. That's exactly right. They want to know that you're a sophisticated counterparty, and an NDA is part of that. Again, it comes back to the point before. If you start making unrealistic asks, you'll lose that credibility. But otherwise, it's fine. Yeah, but it is one of the hardest things to do, and especially also with employees, interns, and so on, because people get a bit nervous about signing NDAs. How are we going for time? Okay. Yes. Couple of other things in NDAs that you might want to look for, again, depending on which side you're on, but if we talk mainly around disclosing, one of the big things in an NDA is we're talking about secrecy and confidentiality, but the other thing is intellectual property ownership, particularly employees and interns, but also partners and so on. If you've developed the intellectual property, it's worth putting in an NDA that any disclosure of information you make is your IP, and the other party doesn't get any claim to it or any right to it because you're disclosing the information to them. Now, these IP provisions can start to get a bit complicated because they can start talking about background IP, pre-existing IP that's generated out of discussions and so on. So they can get a bit fiddly. Again, that's probably where you want to get a lawyer involved, and that's probably at a more advanced state. But certainly with employees and interns and new people coming into the business, I would suggest you always include a clause that say any IP that you generate in the work you're doing for me under this NDA belongs to me, belongs to the company, not to you. It's a very important one to do. And then the other one, probably more for investors and probably more for big NDAs, less relevant for us, is you have a whole lot of hidden clauses, or not hidden, but sort of side clauses that people will try and slide into an NDA, particularly if you're dealing with a listed company, a BHP or someone like that. They'll put in sometimes lock-ins saying you're not allowed to trade their shares, you're not allowed to disclose any information from theirs because it's confidential information. So you need to look at those other things. Again, less of an issue for us at the stage we're at, but just be aware when you're reading an NDA, review it mainly, look at it from the point of secrecy and IP, and anything else in there probably shouldn't be there. So just sort of keep an eye out for a red flag that way. Okay, last point here, and this comes back to, I think, what we raised right at the beginning. You go through all this pain, you create an NDA, you go through the embarrassment or the process of having to raise it, and then you get the NDA with the company. It is not your magic panacea. It's good to have, and it's helpful for future business, but it doesn't stop the other side from doing the wrong thing. So if they go and do the wrong thing, the only thing you can do to manage that is take them to court. And that's expensive and hard, especially if the other side's got money and you don't. So you can apply pressure, but what I would say is once you've got an NDA signed, don't just sit there and go, okay, I'm rock solid, I'm fine. You're not at all. It's a nice thing to have, but if the other side's got power, it really doesn't mean all that much. So that's the other thing to keep in mind when you're doing it, is it won't fix everything. The better thing for protection in that regard is intellectual property, which we had the session on separately. If you can get a patent, if you can get registered, designs or so on, that gives you really strong protection against someone. An NDA is much harder to sort of use to try and enforce your rights if someone else takes your idea and copies it. Okay. Next one, please. All right, just quickly, and we haven't got a lot of time, but just to cover a couple of other quick things, one in particular. So Charlie spoke about it a little bit, and also I think one of our other workshop speakers spoke about a shareholders agreement. A shareholders agreement is effectively, it's like a prenup is the easiest way to put it. If you enter into a deal with any other party, a business partner, a strategic partner, an investor, they basically have become, your family in your business. And like any other family, families disagree and they have fights, and then there's uncertainty about what you do with the assets, and your business is the asset. So the idea of the shareholders agreement, or joint venture agreement if you have an unincorporated deal, is it tries to cover all of those issues where there might be disagreement or a change in the way the business has gone. So, things that it will typically cover will be if there's two or more of you, which there'll have to be two or more of you for you to have one. But if there's like three or more of you, how do you make decisions between the three of you? Is it unanimous? Do all three of you make a decision? Is it a 50% vote? So you only need 2 out of the 3. If there's more of you than that, you need to work that out. That is a really important thing to put down on a piece of paper if you're going to a partnership with someone up front. And if it's like a 50-50 deal, what do you happen if there's a tie break? What if one wants to do one thing and one doesn't? One wants to go forward with the business and you all got to put some more money in and the other doesn't. You've got to have a hard tie break, some way to work out what happens. That tie break may be you go off and get someone else, but more commonly, it'll be some ability to buy the other party out if they're not willing to go ahead, or for you to fund it and to dilute the other party. So shareholders agreements, they are complicated documents. You need to get proper advice on a shareholders agreement if you're going to go and get one in place. Again, I would qualify that by saying any agreement is better than no agreement. So if you just write down the basics on a piece of paper or on a napkin, that's better than nothing at all. Talk about governance, talk about how you're going to do your voting, talk about your tie breaks, talk about exit events. So if one of you wants to get out of the business, what then happens? The other side buys you out. How do you value it? And then in particular, another key one is funding. If there's 2 or more of you and you need more money and you're going to put more of your own personal money in, what if the other person doesn't want to put their money in? Same thing. Do you buy them out? Are they forced to put the money in? Do you lend the money to them, or do you put the money in and dilute them? There's lots of different combinations and options there. So these are hard things. They're not easy to address legally. They're not easy to address when you're talking to your business partner or your founding partner either. So they are difficult conversations, just like family conversations that are difficult. They're really, really important to have. So please, if I say anything, and as Charlie has reinforced to you many times, if you've got business partners or co-founders, spend the time working through this. I think we're probably out of time now. So otherwise, early stage licensing and royalty style agreements, they'll pop up. I know for some of the teams here, particularly I think the PhD guys, you're dealing with commercialization bodies from some of the universities. Get legal advice on that stuff. See what their royalty terms are, see what the take is down the line from the university, because that's negotiable. That's a really important thing to spend time on. Just a personal point from a previous business I know, if you do get intellectual property and you have it and it's valuable, you get a patent or something like that, my suggestion is always that if you then get your business up and running and you're making money with that business and you've got customers, put your IP in a separate company, not in the same IP ownership company, because trading companies, they're risky. If they run out of money, if you don't get the cash flow and the business folds, and your IP is in that business, you lose your IP, it's gone. Whereas if you keep it separate and you license it, you can sort of keep the IP protected in case you need to try and start the business up again or do something else. So keep your IP ring-fenced if you can from your trading business. I would suggest that is a really good thing to do. Only, of course, if you've got valuable IP.